Hi, my name is Shazia Khan, and today's unit we'll be looking at is contract law, and it's unit number 3.28, and we're going to be looking at learning outcome 6, which is to understand the legal issues of duress and undue influence. In the last session, we looked at learning outcome 5, which was to understand the legal issue of frustration in regards to how a contract is frustrated. Also looking at the legal consequences of a contract, how a contract is void under common law. We also looked at the difficulty in establishing a frustrated contract, and we looked at the elements of events leading to a frustrated contract, such as destruction, strikes, effects of law, effects of war, personal services, and government intervention. And we looked at legal authorities and legal case laws in regards to that. Now we're going to look at learning outcome 6, which is to understand the legal issues of duress and undue influence. So the learning outcome is to explain the concept of duress and undue influence. So 6.1 is to explain the concept of duress and undue influence. So duress and undue influence, sign the will or else. So this is an example of pressure under duress and why someone would get into that pressure in regards to trying to force someone to sign a contract under undue influence or duress. I'm going to put a video on now that establishes the difference between duress and undue influence.
The defenses that a party may raise. The final two types of defenses that a party may raise are undue influence and duress. Let's look at these related concepts in turn, starting with undue influence. Undue influence means that a dominant party uses unfair methods of persuasion to cause a susceptible, weaker party to enter into a contract. That contract is an agreement that is against the weaker party's best interests. Undue influence in this sense may include a broad range of tactics, including the following: exercising constant pressure on a party, trying to get them to conclude an agreement; creating or exploiting a situation in which the victim needs to act quickly or believes that they need to act quickly; a situation in which the victim doesn't have access to independent advice concerning a contract; finally, exploiting a victim that is infirm or otherwise vulnerable. For example, if a handicapped person living alone and with few contacts to the outside world and dependent on a carer agreed to sell her house to the carer at a bargain price, a court might set aside that agreement based on undue influence. The consequence of undue influence is that a contract is voidable at the option of the vulnerable party. Duress is similar to, but more direct and forceful than undue influence. It involves wrongful threats that are made to coerce someone into entering a contract. Again, there is a range of behaviors that may be relevant. They include blackmail, extortion, and physical threats. Duress is, however, present only if the threatened act is wrongful or illegal. Therefore, more subtle forms of pressure will not constitute duress. The threats can be personal, involving fear of one's life and health, or economic in nature, which involves financial concerns. In terms of the latter, in case of economic duress, courts are willing to set aside contracts on that basis when the following elements are present: the party alleging economic duress involuntarily accepted the terms of another; the circumstances permitted no other alternative; and the circumstances resulted from the other party's wrongful and oppressive conduct. For example, a court found economic duress when a company withheld payment of an acknowledged debt of $260,000, knowing that the other party had no choice but to accept its offer of a settlement of the debt for $97,000 because of the party's own pressing debts. The consequences of duress may be twofold. First, the contract is normally voidable at the option of the coerced individual due to duress. The party that received the threats may therefore choose whether or not it wishes to raise the defense. If it decides not to raise it, the contract will stand. Second, however, in cases where the threat is immediate and involves actual physical compulsion, then the contract is void. In contrast to the first scenario, the contract never forms and therefore the coerced party doesn't retain the option not to raise the defense. This scenario would include, for instance, a party that points a gun to another person's head and forces that person to sign a contract against their will. In this scenario, the contract would be invalid.
So as we can see from the video, identify the difference between duress and undue influence. So you've got an idea before we carry on. So duress is when a person is forced to do something against his or her will. That person is said to have been the victim of duress, which is compulsion. In the context of contract law, this refers to where a party uses duress against the other party in order for them to enter into a contract which they do not want to, or where the terms of the contract are unfavourable to them. A contract induced by physical violence is void. If we go back to looking at the doctrine of both duress and undue influence, these doctrines both provide a means for an individual to avoid an already concluded contract. These doctrines operate where the individual has been forced or coerced into the contract, as the video said, by threats, unfair pressures, or unreasonable influences. The justification for these doctrines is fairly obvious. It is that it prevents one party taking unfair advantage of another. The effects of these doctrines on contract is that it makes the contract voidable at the request of the aggrieved party. Duress by threat of violence. So if a party is able to prove they were coerced into a contract due to threat of violence, the contract will be voidable. There are two main requirements of duress by threat of violence. The nature of the threat must be sufficient to amount to duress, and the effect of the threat must have been that it forced the claimant into the contract. Duress by threat of violence. So when an example of duress is would be physical abuse by an abuser, so hitting the victim until they gave the abuser valuable jewelry. Providing undue influence is more complicated. So an example of undue influence would be an abusive spouse to withhold affection unless the abusive spouse were to be given valuable jewelry. Duress by threat of violence. The nature of threat. The threat made must be sufficient in its nature to amount to duress. Usually the indicator the courts have used is whether the threat is illegal. And the leading case for this is the case of Barton and Armstrong, 1976. And in this case, it was to do with an authority for this point. In this case, a threat of murder was one that amounted to an illegal act of sufficient nature. So the effect of threat, the distinction to make when ascertaining the effect of threat is whether there is a threat which results in a claimant voluntary entering the contract, or whether the claimant involuntarily entered the contract. And the leading case is the case of Northern Ireland and Lynch, 1975. And this case provides an effective explanation of the issue of threat. The judges accepted that even in extreme circumstances, there's always usually an option, but it must be the only option is realistically available. In contract law, there was the unwillingness to accept the position in Northern Ireland and Lynch. It has been suggested that the claimants must be overborne and he must have no choice. However, in the case of Barton and Armstrong, surely despite the threat of murder, there was still a choice. Overall, it can be concluded that the threat must be one which is illegal. Economic duress, and the doctrine of economic duress was established in the case of Pu On and Law-Lo6, 1980. In regards to Lord Scarman set out these two requirements: coercion of the will that vitiates the consent, and the pressure or threat must be illegitimate. Economic duress refers to a threat of an individual's financial interests. A typical scenario of such duress would be always Party A and Party B negotiate contract. Party B threatens to breach the contract unless contract is renegotiated. Party A opts to renegotiate the contract in favour of Party B because of the potential outcomes in B were to breach the contract. In this situation, a breach of contract by Party B could have any number of unwanted consequential results for Party A. Perhaps the contract is a subcontract, and if Party B breached the contract, Party A will be liable in damages to another party. The doctrine requires a fine line with commercial needs of society. Legitimate economic pressure can be recognised as a useful negotiation tool, and the courts risk going too far with the scope of economic duress. In the case of Poe on 1980, the plaintiffs in this case owned the shares of a private company which owned a building that the defendants wanted to buy. The defendants were majority shareholders in a public company. P agreed to sell their shares in the private company to D so that the D could acquire the building in return. In return, P could get shares in the public company. Fearing a drop in share value of the public company would result, P and D made another agreement that P would not sell their shares for a while. However, P realized that D might profit from this agreement and demanded this second agreement be replaced with one in which P was indemnified for any fall in share value, but might also benefit from any rise in the share value. Fearing that not agreeing to this would delay the main contract, D agreed. The share value did drop and P sought to rely on the indemnity contract. D refused to comply with this and the case reached the Privy Council. The issue that was identified in this case was the defendants claimed that the consideration for the indemnity agreement was past consideration and had only been agreed to under duress. The court found for the plaintiffs applying the exception to the doctrine of the past consideration in the case of Labley and Braithwaite 1615, where Lord Scarman said that an act done before promise was made was good consideration for that promise if it was done at the promiser's request and the parties understood the act was to be paid for at a later date, and the payment or benefit would have been enforceable and it had been promised in advance. The first requirement that requires a coercion of the will, that consent, was highly criticised by academics such as ATHE, and it was criticised in the case of Dimscal Shipping Company and International Transport Workers Federation 1991. Lack of practical choice. A practical example of this principle in operation can be found in B&S Contracts and Design Limited and Victor Green Publications 1984. In this case, there was a contract to erect some exhibition stands. A week before the due date of the contract, the builders refused to work unless they were paid more money. If the claimant had not paid the extra money, they would have suffered serious loss as a result of the contract they had involving the completed exhibition stands. In this case, they had no realistic option but to pay the extra money to avoid the serious losses. There's also a couple of more examples in case law that I want to identify in regards to conduct that would amount to economic duress. The case of Atlas Express Limited and CAFCO Importers and Distributors 1989. In this case, CAFCO were contracted with a third party for the supply of baskets. CAFCO had an agreement with Atlas Express for delivery of the baskets. Atlas Express realised they had miscalculated the size of the basket, so would have to spend more on delivery and cut their profits. Atlas told CAFCO if they do not pay a higher price for the delivery, they would not deliver the baskets at all. CAFCO had no choice but to pay the higher price, as if they did not, delivery of the products of the third party wouldn't go into liquidation. They paid the price and later claimed economic duress. It was held that CAFCO had no choice but to pay the price. If they had decided to claim damages for the failure of ATHE to deliver the goods, it would have not compensated them for missing the subsequent contract with the third party, and a claim forcing them to deliver under specific performance remedy would have been too time-consuming due to the immediate requirement of delivery to the third party. Therefore, the only viable option for CAFCO was to pay the higher price. Another case in regards to whether duress is lawful or not is the case of CTN Cash and Carry and Gallagher Limited 1994. In this case, CTN contracted with Gallagher for some goods. Unfortunately, CTN delivered the goods to the wrong place of business. Gallagher attempted to remedy this, but the goods were stolen before they could do so. CTN mistakenly believed the goods were at the risk of Gallagher, as they believed they had delivered them properly. CTN therefore invoiced Gallagher for the goods and a threat of removal of credit facilities if the price was not paid. Gallagher opted to pay for the goods and attempted to reclaim the money based on duress. The courts held that there was no duress because of these three reasons. Firstly, that the parties dealt with each other at arm's length. Secondly, that the threat was lawful. And thirdly, that CTN legitimately believed they were entitled to the money. There was no intention to put pressure on Gallagher. These requirements are difficult to meet when parties are dealing as commas. It is rare they will be dealing at arm's length. Nevertheless, this approach was confirmed in the case of Progress Bulk Carriers and Tube City LLC 2012, where it was withdrawing credit agreement was confirmed as lawful threat in the Bank of Scotland and Cohen. Now we're going to go on to undue influence. So undue influence is defined as unfair persuasion. It is a milder form of duress than physical harm or threats. It occurs when the victim is under the domination of a persuader, or is one who, in the view of the relationship between them, is warranted in believing that the persuader will act in a manner detrimental to the victim's welfare if the victim fails to assent. It is the proper use of trust or power to deprive a person of free will and substitute instead another's objective. Usually the fact pattern involves the victim being isolated from receiving advice except from the persuader. Examples of this are: a child takes advantage of an affirm parent, a doctor takes advantage of an ill patient, or a lawyer takes advantage of an unknowledgeable client. If there has been undue influence, the contract is voidable by the party who has been unfairly persuaded. Undue influence is similar to duress in nature, but the doctrine of undue influence is an equitable doctrine as opposed to the common law basis of duress. The key differing factor is duress is based on threat, whilst undue influence will be based on relationship that has been exploited. The types of undue influence: Lord Brown Wilkinson identified two distinct classes of undue influence in the case of Barclays Bank PLC against O'Brien 1994. Firstly, he identified it as number one, actual undue influence, and number two, presumed undue influence, which can be categorized as protected relationships, so predetermined presumptions as to the relationships which will give rise to a presumed influence, or other cases, relationships in which influence can be presumed but is not automatically done. So in the case of a Barclays Bank PLC and O'Brien 1994, the facts of the case was the defendants were a married couple who took out a second mortgage on their home as security for overdraft facilities extended by Barclays to the husband's company. The wife had no interest in the business. Before execution, the branch manager advised the couple to seek legal advice prior to signing the documents. The wife eventually signed the documents, relying solely on her husband's false representation that the deed was limiting limited to £60,000 and would last 3 weeks only. In the end, the husband's company reached 154,000 overdraft as a result of which Barclays sought an order for possession of the mortgage security, for example, the company's home. The wife appealed. The issue in this case was that the wife's appeal was dismissed for lack of evidence of her husband's misrepresentation. The Court of Appeal then allowed her appeal based on special protection, and she was owed in equity. It held that the mortgage was only enforceable against her to the extent of £60,000, the amount she believed the mortgage was for. The decision was, and the outcome in this case was the House of Lords found in favour of the wife as well, not on the basis of special equitable protection. The court held that the husband exercised undue influence, misrepresented the deed, for example, committed a legal wrong, and thus induced her to sign the deed. As a result, the wife had equity against her husband to set the deed aside. Such equity was enforceable against a third party who had constructive or actual notice of the situation and gave rise to the equity or for whom the husband was an agent. Barclays in this case. The creditor would have constructive notice when the transaction in question was not to the wife's financial advantage and which carried a significant risk of husbands committing a wrong in law or equity. Actual undue influence is, this class of undue influence can be seen to be an alternative manifestation of duress, being conceptually similar. Actual undue influence has been described as acts of improper pressure or coercion, such as unlawful threats, which seems to draw a parallel with duress. As can be seen from the assessment of burdens of proof in a claim for undue influence, it has to be proven that the undue influences overcome their free will. This is similar to the standard of duress, but of course, in cases of duress, it is much easier to prove. It will be an extremely high threshold to prove that the undue influence left the claimant with no choice at all. In cases of presumed undue influence, all the claimant has to do is prove that one party exploited the nature of the relationship, which is in much lower evidential standards, such as, for example, a husband and wife in this relationship. Therefore, you may be questioning why a party would pursue a claim for actual undue influence with such a high burden of proof. As mentioned, there is no need for an existing relationship between the parties to prove actual undue influence, which is advantageous in the event this is the case, as it would prevent a claim for presumed undue influence from operating. Furthermore, the contract attempting to be voided for undue influence does not have to be of manifest disadvantage to the claimant, as in the case of a CIBC, Mortgages PLC and PIT, whereas in proving duress, the contract must be of manifest disadvantage. In this case, Pitt wanted to purchase some shares in order to fund this purchase. He put pressure on his wife to sign a second mortgage over the family home. The application for the loan stated the purpose was to purchase a holiday home and pay off the existing mortgage. Following, the husband used the money to purchase the shares. When the bank sought to enforce their security under the mortgage, the wife attempted to claim undue influence against her husband. It was held that there was no requirement to demonstrate manifest disadvantage where actual undue influence was established. Therefore, there could be a claim for actual undue influence. Unfortunately, due to other issues relating to notice of the bank, the claim failed, but the key principle of no requirement of manifest disadvantage remains for presumed undue influence. Presumed undue influence in the case of Daniel and Drew, 2005, the approach of the courts in this case was in relation to both categories of presumed undue influence was confirmed. The claimant does not have to prove that undue influence left them with no choice. All that needs to be proven is that they exerted some influence over them, enough so that the transaction was not the exercise of their independent free will. The Royal Bank of Scotland PLC and Ettridge case number 2 clarified the approach to presumed influence. The relationship between the party would have give a presumption of influence, but not necessarily undue influence. This was for the claimant to prove. The key test for presumed undue influence was set out in the case of Turkey and Awad 2005. And in this case, it identified three elements, which was, do the facts give rise to either the existence of a protected relationship or a relationship in which evidence could prove that one party exerted influence on the other? If so, could the transaction be shown to be one that could not be explained by ordinary motives, therefore suggesting some kind of undue influence resulting in the transaction? And three, can the defendant rebut this presumption by establishing there was no abuse of trust? Another very important case in regards to undue influence and presumption was the Goodchild and Bradbury 2006 case. In this case, the facts of the case was Goodchild was elderly. He owned some agricultural land. He gave plot next to his house to his nephew, Bradbury, who lived with him as a wedding present. Bradbury's friend, also a defendant, helped to arrange the transaction by introducing Goodchild and Bradbury to a solicitor. The solicitor gave Goodchild legal advice in a separate room. The draft transfer had a covenant which limited the land's development to the construction of 6 dwelling houses. Goodchild approved the draft, but subsequently had a stroke. Despite this, the transaction was finalized. Bradbury then sold the land to his friend. Goodchild sought to set aside both transactions. The issue that was identified in this case was that Goodchild argued that the first transaction was facilitated by undue influence, and Bradbury's friend knew of this fact before the second transaction took place. The solicitor who consulted Goodchild gave evidence that the Goodchild did not pay attention to his advice and did not appear to be under any undue influence. Goodchild admitted that he did not feel pressured to give away a piece of land to Bradbury. It was shown that the development would significantly reduce the land's value. The judge determined that there was no undue influence in the first transaction as per Goodchild, but his own admission did not feel pressured. Goodchild appealed. The court found in favour of Goodchild based on the vulnerability. The relationship between the elderly uncle and the nephew had the potential for abuse. Thus, and as the gifting of land was not inevitable, Bradbury had to show that Goodchild understood and intended the transaction. In regards to protected relationships, the law has deemed certain relationships special, meaning influence between them can automatically be presumed in the absence of the other facts. Once the existence of the relationships have been established, the claimant must prove that the influence exerted was undue. So in regards to duress and undue influence, we've looked at the elements of how someone could take advantage of another person in regards to trying to make a contract void. But if it's under duress and undue influence, the contracts can be voidable and they could be breached, the terms of the contract. And, you know, you're doing it in duress, which is with threat and vulnerability. So these things need to be taken into account when you look at duress and undue influence. So now what we've done is we've finished learning outcome 6 in regards to duress and undue influence with reference to quite a lot of cases that you could look at. And the references are on the next page in regards to what we used to complete learning outcome 6. Also, additional resources will be available on Moodle for you. And thank you for attending this session.